Good morning, everyone, and welcome to the Committee on Professional Responsibility and Conduct. As a reminder, this meeting is being recorded. Karen, can you take the roll?
Yes. Ali?
Here.
Brown?
Present.
Coleman?
Here.
Shivers?
Here.
Guzman?
Here.
Kruger?
Here.
Mercado?
Here.
Mohebi?
Here.
Munoz? O'Reilly?
Here.
Poindexter?
Here.
Ravi? Riley?
Here.
Thank you.
Thank you, Karen. Next on the agenda is the call for public comment. The State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool, and I believe we're taking personal appearances first.
We will allow 3 minutes for each speaker. The on-screen. For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now and State Bar staff will call on you in the order the hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing star 9. That is the star key, then number 9. We will allow 3 minutes for each speaker. The on-screen will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. We will begin with the in-person public comments.
So do we have the first speaker to come up to the, is somebody going to get? Please come up to the microphone there. I think you need to push the little button there so there's a green light on the, yeah, thank you.
Good morning. Good morning to this distinguished, credible institution. I was keep following the bar since the pandemic and also 2021, and also I know how credible, how ethic this work is. And I would like to say thanks to you. But I'm looking at the 2025 bar. That's with a lot of chaos. That's what brought me here today. So I just met someone that even want to commit suicide just because of this issue. And I know we as a human being, I know no matter what, as a psychometrician or whatever, I know we have, despite, I can go through because this person sat for about, I think, 2021, and the computer was crashed. And I was in present. I started to talk to her. I said, look. And he said, oh, Narandas, I got a refund. I said, that's perfect from the bar. I said, that is a perfect decision. I said, you can take it back. He said, no matter what. I was here. I saw her. I went all the time. And she took like over 4,000 study. And I'm the one that now she already gets evicted because of she took time off work over 3 months, and she get evicted. So I'm here, and she missed the bar by 8 points, and the 8 points Mrs. MB. And the same MB called me the day and said, Naranda, guess what? He said, I have a lot of problem to log in and it lack 5 minutes and everything. I said, can you send them an email? And I told, and she said, yeah. And she have 14. And
You
she,
have 30 seconds remaining.
yeah. So she was so demonstrated. I don't know what to say. So that's why I'm here today in front of the bar. I know with all your good work, you can do better. And it's an institution I respect so much. My aunt was a lecturer in Oxford University, and my uncle was a lecturer in Sierra Leone. So I've been here.
Your time is up. Please wrap it up.
So I just want to say, I'm here by the good faith of those people. I know you're capable of doing something, which the one that left out, whatever you can do to help them. I'm here for them. Thank you.
Thank you very much.
Yeah.
Next is 6289. You have 30 seconds to speak. I apologize, 3 minutes. I have it, Angela says she can see it, and I have it going. I should be able to speak now. She should be.
Turn this off.
Kai, you should be able to speak. You go ahead now. She's on there though. Maybe Kai, unmute yourself. Kai? Next is Minty. Go ahead and speak. Please unmute yourself.
Hi, is this working?
Yes.
Okay, great. I've already submitted written comments, but I wanted to take the opportunity to just kind of speak in person so that you know how important this is. My name is Minty Sue Kutnikoff. I am the Legal Services Director at Sojourn, which is the second oldest domestic violence shelter program in the state. And I wanted to thank you so much for adding 4.9 to your agenda. Because we really do need to stop pre-service solicitation of by attorneys. We believe as attorneys in the rule of law. We believe in the proper administration of justice, and pre-service solicitation of clients by attorneys really undermines that proper administration of justice and the respect for law, because it takes people out of court where we believe as attorneys is where things should be properly adjudicated. But with the pre-service solicitation of clients, attorneys are taking the defendants in restraining order cases, giving them advance notice that a restraining order is coming, and then the accused gets to try to bully the petitioner out of the process. The restraining order process takes this dispute out of the court system and into, the private nethers, where people can be bullied, can be injured, can be threatened, and taken out of the way we believe as attorneys disputes should be resolved. We believe they should be resolved in the courts and not by people threatening a petitioner or injuring a petitioner. That's not where our dispute should be resolved. And so, in order to have the proper administration of justice, to have the proper rule of law, the restraining order disputes do need to be resolved in our courts and not by abusers threatening or harming the petitioners. And so, thank you very much for putting on the agenda item 4.9. I really look forward and hope that you will offer safety and support our profession by sustaining our reputation to do public good. Thank you.
Thank you.
Laura, go ahead and start your public comment.
Good morning. My name is Laura McInnes, and I am the managing attorney of Family Violence Law Center in Oakland, California. FVLC is a small nonprofit legal services organization that provides wraparound services and resources for survivors of domestic violence, sexual assault, stalking, and trafficking. We're one of the only domestic violence organizations in the East Bay that provides free legal services to these clients. And a bulk of our legal services entails helping clients prepare domestic violence restraining orders and represent them in family court. I am here today commenting in support of the California State Bar's Committee on Professional Responsibility to bar solicitation of clients prior to service of a temporary restraining order. In our experience, when a respondent is alerted to the fact that they have an impending court case, specifically with regard to domestic violence situations, our clients are at heightened risk of either escalated and or retaliatory violence, evasion of service, which inhibits their goals, and unpredictability and greater fear about our clients' safety. As you may know, the greatest risk for our clients are when they are separated from their abusive partner. During this time, often when they file for temporary restraining orders, they are most vulnerable for abuse or harassment. This rule would help the safety of survivors of violence by keeping this information as confidential as possible until service is effectuated and until they can feel much safer. So I wanted to say I thank you for proposing this rule, and I fully support it on behalf of FVLC. Thank you so much.
Thank you.
Mi-Young, go ahead and start your public comment.
Good morning, and thank you to the members of the committee for the opportunity to speak on item 4.9 on the agenda. My name is Min-Young Lee, and I'm the supervising attorney of the Family Law Unit at Neighborhood Legal Services of Los Angeles County. We represent survivors of domestic violence and sexual assault, most of whom are low-income parents of minor children. I urge the committee to adopt the proposed amendment to Rule 7.3 of the California Rules of Professional Conduct. Soliciting clients in domestic violence restraining order cases before the restrained party has been served poses serious risks. Survivors seeking protection are often doing so shortly after a traumatic event, and filing for a restraining order requires immense courage, especially when children are involved. That process should be respected and not exploited for business. Service of process is one of the most dangerous moments in a DVRO case. Once an abuser learns about legal action, the survivor's risk increases dramatically. And that's why service is so carefully coordinated by survivors and their advocates or attorneys. Premature solicitations undermine these safety plans and can jeopardize lives. The amendment proposed simply requires attorneys to wait until proof of service is filed before marketing their services. This is a minimal burden that preserves survivor safety without impeding legitimate legal business practices. I strongly support the adoption of this amendment and urge the committee to recognize the necessity in protecting some of the most vulnerable individuals in our legal system. Thank you.
Kai, go ahead and start your public comment. Please unmute yourself. Kai, please unmute yourself. Kai, please unmute yourself. That is the end of the public comments.
Sorry. Thank you. All right, 1 second. Next on the agenda is item, my chair's report. I have nothing to report. So next is the staff report, and this is being presented by Rachel Brewer.
We skipped over the approval of the minutes.
Oh, I'm sorry. Sorry. Let's go to approval of the minutes. Are there any corrections or modifications to the open session minutes? Nope. If there are no corrections or modifications, can I have a motion?
Motion to approve.
Okay. Second? Emil? All right, Karen, please take the roll.
I'm sorry, who motioned that?
I did.
Dan
Dan.
O'Reilly. And Emil seconded.
Okay. Emil?
Aye.
Brown? Coleman?
Yes.
Guzman?
Yes.
Mercado?
Yes.
Mohebi?
Yes.
Munoz? O'Reilly?
Yes.
Poindexter?
Yes.
Topeka? Riley?
Yes.
Shivers?
Yes.
Thank you.
Okay. Next is the chair's report. I don't have anything to report right now, and so we'll hand it over to Rachel.
Good morning. Thank you, Cassidy. I am Rachel Brewer, Managing Attorney with the Office of Professional Competence, and I will be providing staff support to this committee. I have several items to report on today. First of all, as you all know, we had the symposium on April 25th. We received very positive feedback from that and are considering making the recorded sessions available on demand for self-study MCLE credit. In regards to the COPRAC committee member appointments, we did hold interviews with 5 candidates, and recommendations were put forth for the 2 open spots with 2 alternates. And this will be upcoming on the May Board of Trustees agenda. We have 2 items that are currently pending out for public comment. The first is proposed formal opinion 19-004 regarding client file release and retention duties. So far, we have received 1 public comment from a criminal law practitioner who opposes the opinion. He provided extensive feedback regarding the opinion in different criminal law scenarios. He was concerned with the cost-benefit analysis of keeping files. And then we also received 2 public comments for proposed formal opinion 21-003, ethics of in-house counsel business transactions with clients. One was an anonymous commenter who opposed the opinion. The written comments are related to an allegation of price gouging by a door company. The second comment was a member of the public who supported the opinion and provided some brief written comments regarding the February bar exam. And then I wanted to turn to just kind of highlight some of the things that we'll be talking about on today's agenda. Back at the January 2025 COPRAC meeting, I know that the committee discussed the 2025 work plan. And we were going to come back and discuss it as an optional exercise to prepare us for the changes that the Board of Trustees is making to sub-entities, including the COPRAC committee. The Board of Trustees did make the recommended changes at the February 21st Board of Trustees meeting. And so the board adopted all of the staff recommendations that currently impact COPRAC operations. And so just as a reminder, those are increasing staff support to reduce drafting reliance on committee members, developing a mechanism for COPRAC to issue short-form guidance without requiring Board of Trustees review. The prohibition on COPRAC addressing UPL issues has been rescinded. And so I know this was again discussed a little bit at the January meeting, but we will want to look into seeing how other states address this issue, and COPRAC may need to develop a more a different process for opinions that involve UPL issues. Additionally, we will be developing a process whereby COPRAC solicits California attorneys on areas of interest and need for ethical guidance. And then finally, as you are all aware, starting next year, we will be required to develop annual work plans for approval by the Board of Trustees. So with that issue specifically in mind, we did bring the 2025 work plan back on the agenda this month, so that the committee can discuss progress and help us think about what is achievable within a year, so that we can start to plan for next year when that is going to be a requirement for the committee. And then finally, our next COPRAC meeting will be June 20th, and that will be remote via Zoom. Thank you.
Oh, thanks, Rachel. Okay, so next on the agenda is Section 4, Item 4.9, the discussion of the draft proposed amendment to Rule 7.3, solicitation and possible solicitation. And then we may have to circulate for public comment and possible approval. So this item is being presented by Carrie Riley. Carrie?
Hi, good afternoon, everyone. I apologize that I am off camera. I ended up having to be on the road today, and to spare everyone from motion sickness of being in the backseat of a car, I'm going to be camera off. But thank you, everyone, for the opportunity to present the work that Sakita and Eleanor and I worked very hard on and are very proud of. We really appreciate that this is brought to our attention, and the public comments that we have received in support of the draft have been greatly appreciated. And so this is the proposed amendment that we have come up with. There's a little bit of an introduction as to the issues that we are solving for, as well as the balance that we're striking between the respondent's right to counsel while still protecting the petitioners in these time-sensitive hearings. So does anyone have any specific questions about the draft that we have put together, or have any concerns about the triggers that we have included for when solicitation would be acceptable under the new rule?
I have a question, and I apologize if this was already addressed. I missed the last meeting, so feel free to stop me anytime. Is there any reason the court systems themselves cannot just refrain from putting these names on a public docket until there is service? Is there something that prohibits the courts from fixing this in what might be a more straightforward manner than a modification to a rule of professional conduct?
I think we did talk about that, although I don't think we have, well, I have a vague recollection. I don't think we came up with any definitive response, because it was, you know, there's the free speech issues and, you know, the motions to seal are always difficult, and we didn't know how that applied in the DVR context.
Okay.
So I'll let the.
And also and also these hearings are not private or conducted in chambers. And so even if we were to somehow privatize the dockets, it still wouldn't prohibit attorneys from sitting in courtrooms where these are heard. For example, the county that I used to be a DV prosecutor in actually had a domestic violence courtroom where we heard all of the domestic violence cases. So it wouldn't be difficult for an attorney to just simply sit in on the morning calendar and jot down the names of the respondents in those cases.
That's very helpful. I appreciate. Okay, great.
I have a question, Carrie. This is Dan. Cassidy mentioned the free speech issue, and there are others that courts and other bodies have adjudicated based on how we don't limit solicitation for certain reasons. Did you draft around those with this amendment? The way we usually handle that is not to relitigate that in the rule, but just to defer to those and try to draft it so that it doesn't run afoul of the previous jurisprudence. Does that make sense?
It makes sense. We didn't specifically address it here, but we did address the also reference the family code, which already has oh, sorry. Can you guys hear me now?
We can.
Yes.
Can you hear me now? Yeah.
Yes.
Okay. So, apologies. And also, if Nikita or Eleanor want to jump in if I'm cutting out, from that.
I'm happy to. You are cutting out there a little bit, so I'll
Protect
jump
the
in.
public.
Hopefully your reception will get a little better. I think the way that we addressed it was to just do it as narrowly tailored as possible, and figure that in the balance it was worth protecting the public, and it would come out in favor of the rule because it was narrowly tailored.
Right.
So we kind of applied a strict scrutiny type standard.
That makes great sense to me, and I don't think it would change the enforceability or challengeability of it if you cited something, which we've done in other circumstances, as long as you thought about that or looked at that.
We thought about it. We tried to keep it narrowly tailored. We did look at other rules. I can't remember the jurisdiction now. Might have been Colorado. There's at least one other rule out there that is very similar to what we adopted.
That was my next question.
That's held up.
Yeah. Okay.
So far.
Great.
So.
Oh, that's good.
That is good.
Do you guys want to address the public comments that were, I was able to look at most of them, but were there any public comments that raised concerns?
I thought they were all favorable, and in fact, perhaps gave even, more arguments for why it would hold up and how narrowly tailored it is, including, it doesn't interfere with the respondent's right to seek counsel in any way, and they also have the opportunity for continuance apparently as a matter of right, so.
I'm thinking of if you are one of the lawyers who is possibly going to be in a position to solicit people by just being an open court, you would have the ability to tell when process was served by looking at the court docket.
The docket.
And so you could do it then.
That's right.
Okay.
And that's what the rule says. Wait until it's on the docket. The proposed rule, excuse me.
Right, so the concept is that record is accessible to you, so you can go look at that.
If I may, I'm strongly in support of this. I'm wondering if this is the most important outreach educational thing, because I don't suspect that a lot of the folks that are just sort of hanging out and the soliciting clients, attorneys that are doing that, are watching the COPRAC meetings. So how do we make this really clear to the specific, it doesn't go to whether we approve this, but just as an additional point, how do we educate the lawyers that need to know about this if it becomes a rule?
That's a really good question. Maybe we can do some CLE on it as well. It would help get the message out. But I think the staff might have a good suggestions for that. I would defer to staff on how best to go about that.
And we could even consider, informing judges of, I don't know.
Yeah,
the judges that preside.
That's a good idea.
That's a really good idea, I think. And we can also do an alert. This could be our next alert, me and my alerts.
Have we had it?
When the rules were changed recently to be to the self-reporting that attorneys had to report other attorneys. There was a ton of education that was pushed out through the state bar and through other avenues to ensure that all attorneys were aware of the new rule. So I can see something similar here.
So I have a couple of questions. So thank you all for your work on the draft. But just to be clear, the way the posture we're at right now is we would need to approve this. It would need to go for public comment. Then it would need to go to the board and then the Supreme Court. So there's a lot more. Okay. And then the question I had, so, we're thinking about commercial speech, and this has been narrowly tailored. When we go to other jurisdictions, so far there's, Eleanor, I think you had mentioned there's Colorado was the one jurisdiction?
I don't trust my memory on that, but I can share that with the committee.
Okay. I assume there is a problem. Obviously, we had a lot of public comment on the issue. I'm not personally familiar with it. Doesn't mean that it didn't happen. But my point is, if one state has done it and now California is doing it, is there a reason why maybe the ABA hasn't thought of it as an issue? Because the ABA has gone from stricter solicitation rules, like we look at the advertising rule changes in Virginia, and then ultimately at the ABA, and slowly states are adopting them. Is this really the place where we should do it? Is it really the ethics rules in California, or is it, and I think one response to that is it has to start somewhere, but is the court system a better place to do it? Temporarily seal the docket, et cetera. And I think the answer to that is you can't seal the docket. It's kind of like going ex parte, is they have a right to appear, they have a right to notice, they have a right to all those things. And in terms of solicitation, are we saying that a potential respondent or defendant does not have a right to quote unquote access to counsel? Because some people don't know where to find a lawyer and they wait for themselves to be solicited. 100%, I've seen very bad attorneys solicit, 100%. So I'm not going to discount that. And I realize that alerting somebody to something could cause problems, but would we rather have them have the ability to have counsel come to a hearing to defend whatever position is, good or bad?
Can you guys hear me now? My reception better? Yes. Okay.
Yes.
Great. I'm a little confused by the ABA comment, because the ABA, while it provides model guidance for jurisdictions, it's not binding on any licensees in any state. So I'm not sure why we would want to kind of kick this can down the road for the ABA to comment on it and then for us to later adopt it if the ABA took a position that aligned with what we're trying to do here. And again, like Eleanor said, of course, respondents are entitled to counsel. They're also entitled to a continuance if they are not able to find counsel prior to their first hearing. And so I think that this rule strikes a balance between all of those competing interests, and then ultimately errs on the side of protecting petitioners in these hearings where the family code has already codified that it is the most dangerous time when a person is trying to leave an abusive relationship. Domestic violence accounts for 15% of all violence crimes in California and more than 10% of all California homicides. And so it really seems like an important balance that can be struck here without too much onus on the respondents.
Well, to Emil's point that he suggested that an important part of this is having people who don't have contact with lawyers get representation. This would happen after they were served, and people could be contacted. It just wouldn't be happening pre-service, and pre-service is the whole point, correct?
It gives the court time to put protection orders in place. It gives the petitioner time to plan and seek protection, or not be available to be contacted, et cetera. So that's the idea, is to create a buffer so that they have time to react and to protect the petitioner.
And the state that has a substantially similar rule already in place is Pennsylvania.
Oh, thank you.
This might be a very dumb question, but can you explain why this revision prohibits conduct that is not already prohibited by the rule itself, the solicitation rules? Because a lawyer shall not by in-person, live telephone, or real-time electronic contact solicit professional employment. So if they're in person in court, going up to a respondent who's they haven't represented before, they don't have perfect, they're not a lawyer. So how is it not already prohibited? I support the rule, just I just wanted to make clear that I understand what we're talking about here.
Yeah, so just to clarify my point earlier about an attorney being able to sit in on these proceedings, the respondents are typically not present for the initial TRO hearing. That is where the petitioner goes in ex parte and is able to get the order. And then they usually have time to get an exit plan in place, get all of their ducks in a row, and then have the respondent served after they have been able to reach a place of safety. And so I wasn't referring to attorneys sitting in a courtroom soliciting respondents in person. I was referring to, even if we privatize the dockets, someone could still sit in a domestic violence calendar hearing, write down the names of the respondents, and then go and solicit them and let them know, hey, a TRO was issued against you today and a DVRO, and so that was my point.
That's the question, is that conduct would be prohibited by 7.3A already, we think.
Because it's either live telephone or real-time electronic, so it's telephone call or email. So how are they contacting? Yep. Oh, can I have? Yeah. Thank you. And tell us your name too, and I can't.
Yes.
No, we can't. Sorry,
My
we
name
can't.
is
Wait. Sorry. We just want to make sure we have the rules followed. Hold on one second. Okay. Yeah, sorry, it's a public comment. I apologize. We don't usually have people in person, so you can't comment. I know, I'm sorry. So we'll have our discussion, and we're just trying to work out these issues. And we'll invite public comment, because it's going to go out for public comment again. So I do encourage you to, whatever you're planning on saying here, say it in public comment, in the event it goes out for public comment again. Okay? Thank you. Sorry.
Yeah, maybe if you don't mind, I'll make a point. So I think it may not actually be live in-person solicitation. It could be the same way that, you file for a new corporation and you get all these, letters in the mail. You file for a trademark, you get letters in the mail. They're all public records. People scrape them. You get into a car accident,
Sure.
People are probably doing something. And I did look up 7.3 in Pennsylvania, and it does say, a lawyer shall not solicit professional employment even when not otherwise prohibited by paragraph B if, and it goes through a few points, which are the normal points. Then it says, the solicitation is directed to a party who has been named as a defendant or respondent in a domestic relations action. In such cases, the lawyer shall wait until after proof of service appears in the docket before communication with the named defendant or respondent.
Right, so, my thought is to make it clear that to the extent conduct isn't otherwise prohibited by the rule, that was, I think, that was, yeah. The revision doesn't say that, right?
No.
Yeah, I
Yes,
think
Novella,
yeah.
Novella has a question.
Yep. Sorry, Novella.
Yeah. I was thinking of how it addresses conduct that's not otherwise prohibited by the rule. So I agree that the live solicitation thing obviously covers live solicitation, but going to the second point of people, attorneys reaching out based on the information they've learned via written communication, the rule only says currently that you have to put advertisement on such written communications. So there could still be scenarios where attorneys like check the docket or sit in the courtroom and learn that someone is going to be a respondent in a DVRO proceeding, and then they can know that that person is going to be in need of legal services and reach out before service via written communication, as long as they put advertisement on it. So it's still like that wouldn't be enough to get around the concerns that are listed in like number 1 through 4 in the beginning of this document.
Is it, is it considered, still considered an advertisement if it's a targeted, communication to one person? As long as you put advertisement on it, it falls outside of the rule? I don't know the answer to that question.
So California's rule is a little bit more unique. It says, as used in this rule, the terms solicitation and solicit refer to an oral or written targeted communication initiated by or on behalf of the lawyer that is directed to a specific person and that offers to provide or can reasonably be understood as offering to provide legal services. So slightly different than an advertisement.
But hearing that, it means that.
It has to be target, yeah.
Well, what Novella just described would be prohibited by A.
Yeah.
Yeah, I mean, my concern about I'm all for the policy and the purpose of the revisions. I just want it to be upheld, and I don't want it to be ambiguous to the extent that, if it already prohibits certain conduct, if the rule already prohibits certain conduct that's being encompassed by the revision, then it could create confusion. So I just want to make sure that we have it as clear as possible so that it does pass. That would be my only suggestion, is to put in language that says to the extent it's not otherwise prohibited by the rule.
And I'm sorry, I'm going to ask a question out of ignorance. A refers to, existing rule, subsection A refers to real-time electronic contact. C refers to electronic communication. Which of these is an email? What's
That's a good question.
Is there a difference?
I wish I had my book with all the.
I just don't know what that means, because if you're allowed to just email, absent this revision, if you can email specific people, if you market advertising and you're complying with the rule, which C tends to suggest, then this is a really necessary revision in this context.
But an email would be under E, it would be a written targeted communication.
Yeah, but what's the difference? Are you saying what's the difference between electronic communication and real-time electronic communication?
Exactly.
Or electronic contact?
Is there a difference?
What's a real? I mean, I can't imagine that the drafters and whenever this particular rule was thinking like texting or all the, the way kids speak these days, Snapchat. I mean,
Yeah,
so I was thinking real-time electronic contact. I'm assuming they were thinking email, and then electronic communication could be could be a broader. I mean.
Well, C says you can have an electronic communication if you market advertisement, right?
Right. So like on a website.
And you can do it to a person known to be in need of legal services.
Yeah. So I think.
Any person, right?
Any person.
Yeah. I think maybe instead of paragraph F, this would fit into paragraph B. It could be a new B3, because B says a lawyer shall not solicit professional employment by written, recorded, or electronic communication, or by, paragraph A, in-person, telephone, or real-time contact, even when not otherwise prohibited by paragraph A, if, and it says, if the person basically says, don't solicit me, 2, if it involves coercion, harassment, et cetera, and then it could be 3, if it's domestic relations issue.
That's kind of the Pennsylvania approach.
Yeah.
But do we separately want to clean up the difference between real-time electronic communication and written communication?
Now that we're proposing revisions to this rule.
To me, like a Zoom call would be a real-time electronic contact, but that's not what they intended for sure.
Or like a
No, but that's the same thing as
WhatsApp?
telephone or in person, right?
Right.
So I think that it would be a chat room, would have been the old version, and I think there's old opinions about that. I don't know about in California, but yeah, real time would be, like today on a Zoom hearing, it's not telephonic and it's not in person. So I'm not sure, I'm open to that, but I'm not sure if it's a problem right now.
It's definitely not the problem, but I still was confused walking in the door, so.
Right, because there are multiple different,
Your explanation makes it make sense. Maybe it should be revealed in the rule somewhere.
Doesn't appear anywhere else in the rules, that language. So it would be, if we cleaned it up here, it would take care of it.
cleaning it up by saying that it is just electronic communication.
Well, okay, so what are we doing then? Are we gonna, because I think, our goal here is to actually get this out again for, I don't want to table this rule or anything, but do we really need to clean up this language in conjunction with this proposed revision? Or will it delay approval, is my question.
Well, what does staff think on that? Could we just add a note saying that we think that that's not particularly helpful and recommend that, the real time be removed for consideration and not make it part of the proposal, but just a suggestion?
Well, this hasn't gone out for public comment at all yet. So whatever changes need to be made, we can make, and then it can go out for public comment.
I think there's a desire to not muddy it, like to keep it focused on the key issue, but also to make a recommendation that perhaps that adds some confusion and could be cleaned up. But
Even
not
if we
to-
just took out the phrase real time, that would significantly narrow it.
I mean, we could do it. If that's the recommendation, we could just remove that if people are comfortable with that. And then we could also add the, even if not otherwise prohibited language.
Okay, well, let's look at the revision and see if we can, does everybody agree with that?
Just to go through the logic.
I need clarification. Can you put on the screen
Yeah,
specifically what we're talking about?
Yeah.
So the idea is if you were a lawyer who was making this solicitation.
I understand that, but I want to see the little language.
So paragraph, I think you just passed it, it's paragraph F right there. Yep.
A lawyer shall not, okay, let me just.
And just to recap, I guess, since this hasn't gone out, my friendly amendment would be to put this into new B3.
In the what?
F would be, so.
Well, let him say what you're
Okay,
saying.
so for example, right now it's a whole phrase, a lawyer shall not solicit. Instead, a lawyer shall not solicit is already in Rule 7.3B, and it says you shouldn't solicit if, and then it gives the settings. One is the person being solicited has made known to the lawyer a desire not to be solicited by a lawyer. We would add a third one that would say something along the lines of the party, the person being solicited is a respondent in a domestic violence restraining order proceeding, or maybe it's, I forget what the Pennsylvania rule says, maybe domestic relations proceeding, until after the respondent has been served and such service appears on the docket.
I think that's a really elegant solution.
Thank you.
And so what Emil just said is not on the document we have, it would be added. And so one of the things, let me just get clarity. So I see we have closed caption, which we haven't ever used, but we don't have anyone typing in what we're saying on the screen that we could see. So just as a matter of process, could you guys just
I'm asking.
clarify how you will be handling these things as we're talking?
Yeah, Karen, can you, let's cut and paste all of F and move it up to B3. Are you able to do that?
So I realize, Cassidy, you know what she's doing, but as a member, I don't know. Like I said, I just came in and saw closed captioning is happening, so.
What do you mean?
Are you doing something with that? Are you actually the one typing it?
No.
No, it's
So,
Karen.
so that's why I'm asking Karen if you could just say what's happening, how what you're doing.
She's-
But she could speak, Cassidy.
Oh,
right?
well, I'm sorry.
Are you asking about the closed captioning or the?
Yeah, what do you want?
I'm asking about process. I'm just asking about process.
Oh, no worries.
not gonna
The
interfere with
closed captions are happening automatically, and I'll be doing the edits by hand.
Okay, so we could see the edits, but now the decision is we won't be seeing the edits?
No. I haven't made any edits yet.
Okay.
Yeah, those are just closed captions. They happen automatically as people are speaking. Yeah.
Okay.
And just a point of clarification, only F appears on the screen right now because of the way the draft is written. So you'd have to add in, the rest of the rule.
Oh, I thought the rule, I'm sorry. I'm sorry. I thought, I wasn't, yeah. Okay, so just, so let that, well, okay, so we don't have it together. That's kind of hard to,
Cassidy, I can put it together maybe during the lunch break, and then when we come back from lunch, I'll have a new one all put together with, if everyone agrees with
Yeah.
Emil's approach, then I can pull it together and have it ready for the afternoon session.
I think that's a good
My
idea.
only question there, and I think the answer, I think we know what the answer is, but B does say it qualifies what solicitation is, whereas F does not. I think B is intending to capture all forms of solicitation. But just to think about whether or not there's anything excluded here that we would want to capture.
And then
And maybe just by removing real time, we're there, but.
I have one general question, and it is, I've heard for years that these advertisement rules are never enforced, and this is one that we would actually want people to focus on. Yeah. What can COPRAC do to make our wishes clear to the bar that this one is different? It's like unique.
Like, can you expedite this, please?
Or can you focus on, I mean, because I could be wrong, but I've heard anecdotally that the solicitation rules are just like never enforced.
Oh, yeah, so they should make it a priority in terms of enforcement, like OCTC, I mean.
Something like that.
Yeah, I mean, it's not, yeah, I mean, they probably, I don't know, I mean, but I think we could probably see how they prioritize their enforcement, you know, categories of enforcement. And
on the judicial threats one, we've talked
Right.
with that office, and maybe once this goes out for public comment, we
Right.
can get that dialogue.
Yeah, I mean, George Cardona was was definitely, though, involved in the judicial threats revisions, so we can use that as a model to, you know, bring them in to enforcing this new rule once it gets out. And
If I were a judge, I would put that in the TRO order.
yeah,
Just.
yeah.
Taped in the courtroom, you know.
And
But
local
even-
rules, I mean,
So
you
when
know.
yeah, those different ways, plus here, even citing the rule, but even make it part of the order. Can't be notified or solicited under this rule until service is complete.
Also, one of the ways that OCTC can sometimes prioritize the cases that it investigates and prosecutes is based by the prescribed consequence, the discipline under the rules. And so we could make a discipline recommendation that would then signal that this is a serious misconduct.
Yeah, I don't know if we can make a discipline recommendation, but one way or the other, but that's an interesting thought, yeah. Okay, so what's our plan? We've got two tasks here. Consider moving F under B as a B3, just make sure that we're not losing anything by doing that. And then and then revising the language itself to state it, you know, to the extent it's not already prohibited by A. So maybe we can do that after lunch altogether. Does everybody agree with that? Okay. Do we need to do like a straw poll, or we're just? I don't think we do. Okay. Okay. All right. So we will finish this one up after lunch. Let's move on. Do we want to take a break? No. No. Oh, it's okay. All right.
Before we go on, can I just ask everyone to just clarify for me the logic of it? Where we started, just very briefly. The idea is that some of this solicitation would be prohibited by A, others would not, would be permissible under C, as long as you put advertisement on the letter, correct?
So we want to foreclose even that for.
Right, so if you put this in B as 3, it's not otherwise prohibited by A. Does that solve the C problem?
No, or maybe it makes it worse, right?
Right.
Okay, hold on. Let's go back.
That's the conduct we're getting to, which is it would be permitted under A, but not C. And so if you say when not otherwise prohibited, it would be meaningless.
So,
I would just flip it, say, like, under no circumstances, more or less.
maybe we could just discuss how this rule is operationalized. So if I walk up to somebody in a courtroom, forget about DV, just go up to the courtroom and said, hey, I just saw you got chastised by a judge and, I can represent you. That's in-person solicitation. And it says in paragraph A, you should not do that when your
can't do that.
motive is pecuniary gain. So if it's pro bono, you theoretically could, unless that person you contact is a lawyer or a close personal friend, family, or somebody you had a prior professional relationship with. So that's already prohibited. Can I technically send that person an email, a letter, if I put the word advertisement, et cetera? And it says in paragraph B, a lawyer shall not solicit professional employment by written, recorded, or electronic communication, or by in-person, telephone, or real-time contact, which is in paragraph A, even if it would not otherwise be prohibited by paragraph A. So what I read in that is, even if they're a lawyer, you could not solicit them if that person has made known to you that they desire not to be solicited, or if that solicitation of the lawyer is an intrusion, coercion, et cetera. Or like, again, if they're a family member, et cetera, it would be normally okay. But again, if a family member says, stop soliciting me. So.
But my argument is that, I'm just arguing here, that even when not otherwise prohibited by paragraph A, limits this prohibition to conduct that is not otherwise prohibited by A. So what if we just took that phrase out? You can't do this under these three circumstances regardless.
Well, I think when it says, and I'm just trying to think out loud, when it says not otherwise prohibited, I believe what it's saying is, even if it's allowed by paragraph A, so that's an
Right,
additional.
but what I'm arguing is, that's the only thing it's targeting, is conduct that is allowed by paragraph A.
Well, but then what's the point of C? I mean,
There wouldn't be even, right? C allows even more conduct.
Right.
well, shouldn't it say even if otherwise prohibited by even when not otherwise prohibited by paragraph A and C?
No, because C doesn't prohibit anything. It just says what you're supposed to do to the written communication.
I'm sorry.
This whole rule needs to be rewritten.
And this is the model,
I always thought it was, anyway, I'm like, California's advertising rules are confusing, I think, but.
If it's confusing to the committee, there might be a reason to consider going with that as an amendment.
Yeah.
To avoid any ambiguity. We read these a lot, so there does seem to be some confusion. We are reading them quickly.
Yeah.
Right.
I tend to read it as fitting in B, but I haven't, I'd like to evaluate it more before we went that route. I think F might be the way, but we could evaluate B.
I would kind of second that.
Yeah.
Because we have some urgency. We'd like to get this amendment out there quickly. And the committee can look at this rule and revise for clarity later, or make suggestions for it, and not hold up this important issue.
And can I just make one last, kind of plea about my explanation for, again, I'm not, glued to that idea, but when it says a lawyer shall not solicit professional employment by written, recorded, or electronic communication, I think that's one clause. And then it says, or by in-person, telephone, or real-time contact, even when those in-person, telephonic, or real-time contact would otherwise be permitted by, so actually.
That's an argument, counsel, but it's vague.
So I think actually a good clarification would be, even when permitted by paragraph A, that might have been a better way to put this. But yeah.
Right, that's probably right. But do we even need that clause?
Which
There are
clause?
three things you can't do in these ways.
Right.
Yeah.
If we lost that clause, it still works, right?
I think so.
And shouldn't B come after C? Shouldn't those be
Yeah.
flipped now, since we're,
Guys,
It's a
we're
bigger
we're
thing.
totally, I trust that there was a
Who drafted
purpose to draft, like why this was drafted this way. So, I mean, I do think, and I think Eleanor's right, we're like reading this so quickly. I think we need to take a little bit of time and think through how C plays into this. Because I do like the idea of F going as a 3 under B, but again, that's just after thinking about it for, 2 minutes while talking about it. So I do think we need to take a little bit of time over the lunch break to really take a look at it and then
Oh,
come
I agree
to-
with that. I agree
Yeah.
with that.
Yeah.
But I just wanted everyone to sort of think about what we're thinking about.
Yeah. So so what we're gonna think about is still whether or not F goes under B3, and let's just figure out what C. What does C mean in all this? Is my broad comment there. Anything else we should be considering over lunch? No.
Cassie Novella has her hand up.
Oh, sorry, I keep forgetting. Who has their hand up? Novella, sorry. Yep, gotcha. Go ahead, Novella.
Thank you. For the part that says, even when prohibited by A, because I feel like just now in the discussion, we've heard like at least 2 views of what that means. I'm hesitant to put in the lunch break, like redrafting and considering deleting that phrase, absent having like looked at the other authority analyzing the rule and how that phrase operates in the context that exists. Because I wouldn't want us to like, oh, in the context of adding this new number 3, we're going to delete it, but we haven't yet even looked at how that phrase operates in the language that already exists. Like that seems like a heavy lift for the lunch break.
Yeah, I absolutely agree with that. And that was my point, is that there's got to be some reason why they drafted it this way. And we can go back and look at the rules revision reports and the comments and the back and forth on this particular rule and determine, why. I mean, I don't even know, this doesn't even follow the ABA 7.3, right? So, I can't even remember the genesis of this particular rule 7.3. But to your point, yeah, I agree. I think making fly revisions to existing rules during a lunch break is risky, to say the least. So that would, and we'll come to a decision after the break, but that would weigh against adding it as B3 and having it as a standalone instead as F, the way it is now. Okay. Anybody else?
I do have a comment. Just
Sure.
I'm willing to see what the lunch produces, but I'm not optimistic. I think we should take the time to get it right. I think how many ever weeks it's going to take to get it right is better than sending something out that's not right. And it sounds like, just from the dialogue in here, perhaps one of the reasons solicitation has a difficulty in being disciplined, as you said, Brandon, is because just in this room, it sounds like it's not clear enough. There's loopholes.
Right.
So it's hard to, and so this is not one that it sounds like people are interested in having a loophole. And
Right.
So my advocacy is, let's look at taking the time to get it right, not just getting something out there that scratches sort of a high level itch, but really in the field of play is not very effective. As Emil goes through, let's see how it plays out in his talking. So that's my take, but I'm open, but I'm really in some way not open to it, because I think by taking it offline, like I heard Carrie said, hey, she'll do whatever, but by taking it offline, now you're really taking it away from the dialogue of the co-prac. So even if we just talked about it, we're supposed to be at lunch, we have people who are virtually, and so I think it sounds like the passion that those who were leading this committee had, or subgroup, it's important enough to have the voice of everyone. So I've been thinking that as I have heard it, and so I'm like, let me just share it
Thanks.
with you.
Okay, Eleanor?
Yeah, I think I would be in favor of leaving it as is and adding the additional language that even if it's not otherwise permitted to clarify things. I think it's worth noting that there's some confusion and ambiguities in the rules. They're drafted a little differently. In some cases, it says real-time communication electronic. In some places, it just says electronic, et cetera. But I think it is important enough to stand alone. And I think for expedience, to get it out there because there is a need and we're hearing about the need from the public, that's what I would propose doing. And I think we can do that quite easily and put it before the committee this afternoon.
Yeah.
I just have one comment. So I was reading the executive summary for Rule 7.3, and if you look at page, I believe it's 2, there's a paragraph that specifically explains information about the history of 7.3B, and in the last sentence it says the commission however determined the additional language in the latter provision, i.e. compulsion, intimidation, threats, and vexatious conduct are subsumed in the 4 recommended terms: intrusion, coercion, and harassment. So it seems like it was intended 7.3B was intended to kind of capture what one of the goals is for F, at least in the history.
Wait, so what page are you looking at?
In the executive summary.
Yeah.
On page, let me double check.
Page 6 of the PDF.
Sorry, page 6 of the PDF.
Okay, got it.
We are going to go ahead and pull 7.3 from the State Bar Public website and display it so that anyone attending via Zoom can follow along.
Great. Okay, and that will include what we're talking about here, which is the executive summary. So you're on page 6. And
there's a description about the history of paragraph B, and I think that's very informative to the conversation.
No, I'm not even looking at my page 6. Is it 7 point? Mine's page 4. Why is yours page 6? It says we're under Rule 7.3, right?
Right.
Of the
executive summary.
And it says paragraph B derived from Model Rule 7.3. That paragraph.
Yep.
The commission, however, determined. Okay. Is everybody reading? Okay.
But I guess rereading this it is talking about compulsion, intimidation, threats, etc. I think that's towards the person being solicited, not the underlying issue, which is I think what we're trying to prevent is the person that gets solicited then uses that knowledge to then go do something bad. But it is helpful to know kind of like, here's the legislative history. And here it does say that, I guess the folks that drafted this recognize that the Supreme Court held that a state could not prohibit direct mailings. And that's the progeny of Bates v. Arizona, right?
Novella, sorry, go ahead.
Yeah, to me, that's a reason not to put it in subdivision B, because now I'm hearing that it's seeking to protect a different population. So given that the population we're seeking to protecting and adding this amendment isn't the potential client, but the other party in the litigation, I think the rationale for B doesn't match up with what the policy goal we're trying to achieve. So that makes me think we shouldn't try to cram it into subdivision B.
I agree with that. When I was listening to Mary Grace read it, that was exactly how I felt about it. So
B is sort of kind of a combination of things that you must not do regardless. 1 and 2 are different than each other. This would be a third different thing.
Yeah, I mean, I need to look at it more closely, but my gut, which doesn't mean much, is that it should go under B. I mean, right, it should go under B, but
Emil, do you think that F, if it stood alone, or even as it's drafted, would withstand the Arizona case that you just mentioned?
Bates v. Arizona. I'm not an expert in con law, but I mean, it is narrowly tailored. It's not that you cannot solicit them, it's just that you cannot solicit them until after they're served and the service appears in the docket. I kind of feel like the service appears in the docket is a little superfluous. I mean, if you have knowledge that they've been served, why not? But, you know, again, not being a con law expert, I think that it could work. But by the way, in the paragraph above in the 7.3 history, it does actually talk about real-time electronic contact, and it says, the term real-time electronic contact has been added from Model Rule 7.3 because the same concerns regarding in-person or live telephone communications applies to real-time contact, such as communications in a chat room or by instant messaging. And then it does, just helping paragraph A, it does also say the 2 exceptions to such solicitations, you know, the lawyer exception or the existing relationship exception, are included because there is significantly less concern of overreaching when the solicitation target is another lawyer or has an existing relationship with a soliciting lawyer. So,
right. So then A is actually the real-time electronic contact limitation is limited to chat rooms and AOL.
Does everyone remember AOL Instant Messenger, right?
right.
That's a much more limited clause than just electronic contact.
Correct. That is correct. So because A is talking only about real time and in person, and that, which is why the point with paragraph B is if it's not, A prohibits it, if there's not an exception to paragraph A, or it otherwise involves any sort of solicitation, then it's also prohibited if it's coercion or if they've told you no already. And then the idea is to say, or if it has to do with the DV case, then.
Okay, any other comments? Hands up? Nope. Okay, so we're still gonna take the break to absorb and digest all of these comments and ideas, and come back and reach a decision about what we're gonna do one way or the other, whether we're gonna revise the rule, leave it as is, and approve it and send it out for a public comment. Okay, so now we're at 11:19. Hold on. My agenda. I think we should. Do you guys want to? I think let's see. Who's doing the next item up is the lawyer's expert witness. Do you want to go over that one?
This can
quickly?
be done relatively quickly.
Yeah.
This is me. Okay. Well, we can decide if we want to go next to that.
Why don't we take a 5-minute break, and then we'll come back and talk about lawyer as expert witness. Okay. Thank you. From the break, and we're going to go on to the lawyer's expert witness discussion. Sorry. Okay, Dan, you are the lead drafter.
Okay, this is lawyer's expert witness. This is 20-0001. We received a request this went out for public comment in probably late February or early March. We got a request from the Bar Association of San Francisco to extend the public comment period because they were in between meetings when that came through and they didn't have time to process it, assign it, and get their comment done. this opinion has been around for a while, but it's substantially changed in the last revision. Section 3 was rewritten, which is why it went back out for public comment. This was the second time it's gone out. But it was different enough from the first iteration that we felt like it had to go back out. So my view, based on the other public comments that we got, which I thought were helpful, which I can touch on in a minute, I would recommend that we approve this to get more information from the BASF, who intends to give us a public opinion. Just for reference, we got 2 other letters, one from the Orange County Bar Association and one from the San Diego Bar Association, both of which were very good, both of which identified tensions that we have been wrestling with this opinion for a long time. Specifically, whether being an expert when a lawyer does it is the practice of law, and the second part is, doesn't the duty of loyalty completely prohibit anything that would be in scenario 3, which we spent many months discussing, and we beefed that up. But in multiple public comments, they wanted more from that, which we could consider. But I think it would be, in the first instance, it would be a good idea to get the comments from BASF, just give them a bit more time. And I don't know, Rachel, what the mechanism for that is, the procedure to extend the public comment period, if we decide to do that.
Yeah, so there needs to be a motion and a vote on it, and if it passes, we can reissue it for a public comment. Given that they were requesting until June 18th, so I think the committee may want to consider a 90-day extension of time to ensure that they get the amount of time that they needed in order to submit their comment.
Okay, thanks. I think that makes sense because we're not meeting again until the 20th of June. And there is not, I mean, for those of us who have worked on this opinion, we obviously considered these issues and balanced them. There isn't a great answer to the question of whether the duty of loyalty trumps all. And we tried to balance that in Section 3. There also is not a clear authority for the proposition that expert work is the practice of law. And obviously non-lawyers are experts, so it can't be the practice of law just when a lawyer does it. That is the problem. And we cite in the opinion to the ABA opinion that says that it is not the practice of law, which is the way that everybody treats it now in my experience. And some of the comments have suggested that it is obviously in many instances, but it certainly isn't when a non-lawyer does it. So those are the tensions that we work through, and the points are well taken, but we consider those, and we will again with whatever the BASF has.
I think Craig might be working on one too, the LA County Bar.
Oh.
But I don't think they issued a request.
They can normally be relied on to opine.
But if there's an extension, I think the odds increase.
Okay, that would be great. If they have solutions to these, we'll be happy to hear them.
Okay, so do we have any other comment or questions? Nope. Okay, do we have a motion to extend the comment period?
I'll make it if.
Yeah, can I make it? Well, I'll move to extend the comment period.
Second.
Okay. Can you take the vote?
Emile,
Yes.
Brown,
Yes.
Coleman,
Yes.
Guzman,
Yes.
Mercado,
She's on call.
Mohebi,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter,
Yes.
DePica, Riley, Shivers.
Yes,
Motion carries.
thank you. Okay, so I think we should take a lunch.
Just a point of clarification, was that approval of the 90-day?
Sorry, do we want to redo it? Yes, it's a 90-day extension?
That was my original intent with the motion, yeah.
Yeah, I think that's fine, okay. Okay, why don't we take a lunch now? Because I think our lunch break was at 11:30? Oh, all right, then never mind, let's move on. Okay, I think we're gonna do the working, work plan now. Okay. So can we put the work plan up yet? Okay, so the purpose of this is just to go over where we are and see if there's further tasks that we want to add to it. So let's start with the first entry. Let's go over the ethics opinions. Where are we? 19. You've just reported on client file, and that was part of your staff report. So that is still out for public opinion or public comment. Is that right? Mm-hmm. Yeah. And then we just talked about lawyers expert witness. That's out for public comment again. Flat fees we're going to talk about today. So that's already on the agenda. Conversion clauses. What were we doing with that one, Brandon?
Eleanor and I are going to meet and do some more revisions to it and try to bring it to a future meeting. Quick question, is Deepika still, is she exiting the committee or still on the committee?
We don't know yet.
No, okay.
We haven't
heard yet. Because, we'll make a presentation at a future meeting, hopefully the very next meeting, and then see if we need another person.
Okay, sounds good. Okay, ethics of in-house counsel, that's still out for public comment, right? Are we gonna review that one on the next meeting? Or do we know in the public comment? I think you covered that one too. I should know.
What are we, 2103?
Yes, sorry.
I think it's with the working group, actually.
No.
It's not. Hold on a second.
Outreach to bar associations for comments. Shoot. Yeah, we did send it out, yeah. It's out, and then I just wanted to know when it closes so that I can prepare. Okay, well, let's move on. The only thing with that one is we just need to know when it public comment closes, but that's one's just still up for public comment. And then cryptocurrency. Do we have Eleanor's? Yeah, we'll skip over that one.
And back to 21-0003, that one's public comment closes May 27th.
Okay, so it may or may not be on the
June.
It should be on the June agenda, but I may not be at the June meeting. Okay, and then 24001, ethics of in-house counsel. What's the status of that one, Emil?
That is a good question. At the last meeting, I think we had proposed to send it out for comment, but there was some concerns that maybe we need to flesh it out more. And so I think our working group just needs to meet and flesh that out.
You're the only person on the working group.
No. Oh, yeah, Vakita was there. You were there. Were you on it, Cass?
No, I can't be because I couldn't be because there were too many, I believe, and I'm on the other one, and frankly, I'd prefer not to be on it.
It was actually, Carrie was on it as well.
Okay. Let's get, well, okay, so let's formalize the working group, because as it stands, it's just you, based on the plan here. So let's make sure Mary Grace is on it. Raquel, is that right? No. Vikita, sorry.
And then, yeah, Mary Grace,
And
Vikita, Carrie, and myself.
And Carrie.
Yeah.
Okay, so that's plenty, right? Does anybody else, we can have more if we want, if anybody else wants to be on it, but it's not necessary? Okay.
And I guess our goal will be that next meeting, we can put something on the agenda.
Okay. And then 250001, that's me and you and Vikita, me and you, Dan O'Reilly, and I haven't even looked at this one. So I think we're probably not going to have that for the June agenda, probably the July agenda. Because we don't even have an outline yet. So we'll put on the work plan to have an outline. Well, just put it on the July agenda, move it out from June. Is that okay? Yeah.
Yes. Did we get a draft from staff on this?
On what?
250001.
No. And I think I need to put together, or I actually do have an outline on this one, but it's so old that I need to revise it and look at it. So the working group should get together and review it, and then we can decide what role staff can play in drafting or researching, or, we can give more direction once we've gone over the outline. So either we'll have a draft of an opinion, which will be super ambitious for July, or we'll have an update as to that process for the July agenda. Okay, and then 2022 OXB determination of reasonable fee. That's the arbitration we just talked about, Emil? And that already went out?
Yes.
Yes. That went out for public comment. Is that right?
I believe it went out last meeting. And it says here to board committee, May 2025.
I believe that at the last meeting, it was voted out to go to the board. So that will be the next step.
Because it had already gone out for public comment. We were just trying to incorporate those.
And then it went up. Yeah,
Correct.
okay. So it's completed the public comment, which we're not used to. So we're like, now what? Okay. Okay, we've got 8.2. That's on the agenda today. I think what we'll be doing is hopefully approving those following, and then wait, that's already gone out for public comment. So we'll talk about that one today. The judicial threats. Oh, the article that's already gone out. Done and done. Ethics symposium. Done and done.
This would be an appropriate time to talk about the ethics symposium if the committee wanted to debrief.
Sure. So we have all the reviews and stuff, so maybe you guys can give like an overview of the reception of the symposium, and then we can kind of talk about anything else, the various panels. No, because I do want to talk about if we want to add anything to it, like a UPL opinion. That's what I wanted.
So the reason I'm asking is because I think the ethics update or any update on any particular thing is outside of the work plan work.
What do you mean?
We're trying to finalize our work plan is what I understood we were doing. So we're not stopped. So we're just saying, hey, where are we? But now Rachel said, hey, let me give an update on the ethics symposium. So I think that's an agenda item. Doesn't go inside of here.
So the ethics symposium was not separately agendized for today's meeting, but it is included in the work plan. So as we're going through and giving updates on the opinions and the rules, we can talk about the.
Yeah, I think it's a good place to talk about the symposium. I think, yeah. Go ahead. Kathy, did you have something to say? No?
If we want to finish going through the work plan, that's fine. There's only one other item on it. And that item is going to come back in July. In terms of the symposium, since it is on the work plan, we didn't agendize it separately.
I heard her answer. I was saying, okay, go ahead. But I think if we start putting agenda items inside the work plan, then we are.
Well, I'll take the case, Raquel, and say that for next year, like the 26th symposium is on the work plan. And hearing about the current one and what we want to do differently is part of it.
That's true.
We had it on the agenda, right? So the idea is to have something that we're tracking with.
Yes, that is correct.
So, and the reason I'm saying it is because there's no sense in having a work plan if we're not gonna really use it as a planning of our work, not doing our work, but planning our work.
Yes.
That's the point.
Yes, so.
I understand how we're gonna proceed, right?
Yeah, and we debated a bit about whether we wanted to agendize it or not, but we decided to do it this way. And since the work plan is not, it's optional this year, we weren't sure if the committee was actually gonna adopt it and.
You don't have to convince me.
Okay.
But you made the comment, Raquel, that the ethics alerts and stuff is not on the work plan. Is that true?
No, I said
It is.
symposium.
Oh, okay, just the
In other words,
symposium. Got it.
What I thought we were doing was try to finalize our work plan. And so Kathy proceeded to go through and say, hey, where are we here? And the ones that are done now.
Unfortunately, we can't hear the comment that Raquel is saying.
Sorry, Vakita, thanks.
Oh, thank you.
So that was what I understood this agenda item is the purpose of it.
Yes.
Is to use it, so we didn't ever finish it. It went back to the committee and staff. They're now presenting it back to us.
Yes.
And we were going to go through it.
Yes.
And that was on the agenda.
Yes.
And so then somebody said, hey, let's start
Yes, your point is
debriefing the
taken.
symposium. Right. So I'm just responding to Dan saying what I said. And that's what I said, and that's why I said it. This is a planning document.
Right.
And that's what we were trying to do. And so I understand you didn't agendize it, and so you want to talk about it, and that's fine.
Well, the rationale would be figuring out what we want to put on for 26 based on what happened in 25. Put on the work plan. The next
Yeah.
ethics
But
symposium.
we
But
don't
it's
even
still, she's
have
still
to
talking,
put-
we're not talking, she's making a distinction between substance and planning. And so since this, right? So,
We're planning, and then all of a sudden, we're debriefing. So Eleanor could say, hey, I want to give an update on crypto.
Well,
It happens to be on the agenda, right? So you go to the agenda. And so I understand. Rachel said, hey, it's not on the agenda, and so that's why we're going to talk about it. And I said, hey, fine, I understand.
well, okay.
Right.
So
yeah, so how about we do it, how about we do this? How about we go ahead and finish up the work plan? We will put the symposium on the agenda for next meeting. And then we can give a full report out and make sure that we have, everybody has what they need and all the information ahead of time.
But I want to think about the symposium in the context of the work plan. That is my point.
Yeah.
So
Right.
you want to, not like we're
Yeah.
going to take it off.
Here's a question. Should we do another symposium?
Okay,
Let's
okay.
think about what happened and decide that. So that's the question.
Okay, let's just talk about the symposium.
Yeah, it's fine.
And thank you, Raquel, because, this, not to belabor this whole point, but it is, I think this exercise, this discussion is important so that we can really flesh out what the what the lines are between work plan, and how the work plan, how we utilize the work plan and how we've been conducting our meetings.
Because we do have a much more of a commitment to using it and sticking with it.
Right.
Developing it so it's robust and then actually executing on it. in my view.
Exactly. Which is gonna be your job next year. Okay, so going back to what I said, can you guys do just a brief overview of the reception, and then we can talk about a little bit of our panels and how we thought they went.
Yeah, as I mentioned during the staff update, we received a lot of really good feedback on the symposium, specifically the first panel regarding the different ethics updates, and in particular the executive orders received a lot of both comments in the chat as well as questions in the question and answers as well. So I think that, yes, I think it was a very successful symposium, and I think given the amount of questions we had, not only on the first panel, but on some of the other panels as well, I noticed that it was hard for the panelists to get to all of the questions in the amount of time, and I know that our panelists for panel 1 volunteered to potentially look at things afterwards. So maybe just in terms of planning for next year, we might want to think about building in some time specifically for questions and answers on all of our panels, so that we can have the panelists kind of go through the questions and pick some out to answer live.
I think that would be good, because on panel 1, I didn't even know they were coming in that quickly. They were coming in real time. There were like 50 of them.
Yeah, it was like rapid fire. Yeah, and I know, thank you for compiling them and sending them out to us, because I like the idea of responding to some of the more important ones and getting them out there somehow. But it is, it's making us do more homework when we could have had a better way of fielding them and answering them in real time in some way.
The AI panel and other panels did that really well.
Yeah.
Like the AI panel specifically, you were processing those questions as they came in, and I thought that was helpful. But if there are questions that don't get answered in real time, or it's too many, I think it would be great to pick a couple.
Okay. Yeah, I think we should have this on the agenda for next time, so that we can talk about more in depth about what we can do better for next year. But I like the idea of, like, for example, designating one of the panelists being the person who answers questions or fields questions and then asks the questions. So maybe we have flexibility in structuring your panels depending on the topic and the people and all that, but I think that might be something that we can push as a suggestion for all the panels. Okay, and yeah, as far as like anything else, Rachel?
No, nothing else for me.
Okay. As far as our panels, I thought both the judicial threats one that I modeled with Vikita, I thought that went fantastic. We got some great, did we get any comments on that one? No?
I'm not aware of any specific comments on that one, no.
And then the first panel was great too. I was really happy. I was really happy with the whole symposium. I thought everybody did a great job. Does anybody have any comments, thoughts?
Are we gonna circulate? Sometimes we circulate the actual feedback.
Yeah.
I love the so.
Yeah, it's too political.
I'll just email you those.
Please do.
They're mostly from me. I would just make a comment for our tech support group that the tech was flawless.
Yeah. Oh my God, that was so good.
Yeah.
Oh, the new, yeah, it really was like a virtual, like it, yeah. It was legit. That was, yeah, it was much more professional than in normal virtual panels and presentations. So, yeah, I was really pleased with that. It was cool.
Yeah, the waiting room especially was hard because you could hear the panel, but you could talk to the other people. Yeah, it was really.
It was like
really
you're
good.
Backstage and you can kind of hear, and then you're talking to each other. Yeah.
There were no glitches as far as I'm aware, so that really went well.
Yeah, thank you.
I do have a question. I noticed some people didn't have their photos, and there was a comment that said some people requested not to have their photos on the deck page. And so it seems like Cassidy and Dan maybe didn't hear that. Does staff have any comment? To me, it made that page look unprofessional.
Did I not have my photo?
I might not have either.
I don't even.
I didn't focus on this. This is a great comment.
Yeah, there was.
I thought we already had our photo.
Did we not have it, or did we have it? We did have it.
I don't know if you I don't remember who had theirs and who didn't.
Because we have our official
Um,
CoPrec photos, right? I
But
mean,
they weren't on the page, like when you click the link and it was where all the material was. There was a
Okay.
lot of blank
Okay.
spaces.
It was.
Yeah, so that made that, I didn't share that page because I felt like it just looked really unprofessional. Like, how would you have a conference with no faces? And one time there was not even, people didn't have bios, but I think by the end of the, but by the symposium, I think at least all the bios were there.
okay.
But the faces were not there. And so, I don't know, Kathy, if you know why some people said, I think Angela told me some people had requested not to put their photo.
Yeah, so this was the first time that we used the Zoom events platform. And so it was a little bit different in terms of getting all the information we needed for that page in a timely fashion. And the photos were not, and yeah, since it wasn't something that we had regularly done, I think that the photo request kind of just fell to the side of but that being said, I know exactly what you're talking about, and we've already talked about it internally, and I think that, that your point is very well taken. And so next year, we will ensure that we get the bios in a timely fashion, and we get all your headshots in a timely fashion.
We're picking up what you're putting down here.
I was gonna say, which is on us, right?
Yeah, because I can't even remember if I even thought about my.
Yeah, there were quite a few that were missing, and I know that they had been submitted. So Cassie, I know I submitted ours as well, so don't know where that happened, but I know that there were quite a few.
Okay, thanks, Vakita.
There was almost like the panelists had people, but the moderators.
Can't hear you, Raquel.
It's almost like the panelists had photos, but the committee didn't have photos, almost.
Okay.
Yeah, not every, some people did, but few.
And I'm sorry.
No,
just
go
real
ahead.
quick. And I am updating the work plan live as we're talking. So if I miss anything, please just let me know. And unless there's an objection, I am going to update this 4 hours to 5 because 4 panels at 1.25 each.
Oh, the CLE?
Yes.
Okay.
Can you say that because of the questions? Is that where you're at? You're adding time or no?
On the, what was your question? I'm sorry.
Are you? I guess let me make sure I understood what you said. I thought you were saying you're expanding the time of the symposium. Is that not what you said?
I think it was just a typo in this document.
Okay.
So I was just updating
So
it
it's
to
just a typo.
correct, yeah,
Okay,
to
not
reflect
actually-
the accurate amount of
okay,
time.
Not actually extending it because of the questions.
Correct.
Okay, thank you.
Okay, anything else about the symposium? And again, we'll do a more in-depth, we'll put on the agenda for next time, and we'll do a more in-depth discussion and planning for next year at the next meeting. Okay, so the last entry is the CoPrec topics, processes, and format for guidance, which is me, Eleanor, Nima, and Vakita. And we haven't really met or done anything on this, but and to the point of, are we gonna add opinion, I want to talk about UPL opinion. Well, maybe that's part of like a working group discussion, and then we present options to the committee, or, I don't know. Yeah.
Thank you. Given your role next year, it would seem to me to make sense that you be part of it if you've got the time and inclination.
That's a really good.
Yeah, I'll join that group. That's fine.
Okay. So, so what we'll do is let's get a working group meeting together to discuss a process for picking opinions, how many topics, presenting, that sort of thing. And we'll discuss it at the next meeting.
That sounds good.
Yeah. Okay, so I think we are at noon. Any other comments on the work plan? Nope. All right, let's take our noon lunch break. Come back at, what do we do? Do we usually take an hour to 45 minutes?
An hour.
Okay, come back at 1. Okay, welcome back, everybody. Before we move on to the next item, I think we're going to revisit the 7.3 discussion. And I think, Eleanor, I'll let you take the lead on that. Do we have, oh, and Carrie. Hi, Carrie. Okay, so we're going to have a proposed revision to the revision. Do we have?
Yes.
Okay.
So I will pull that up now.
Great, thanks.
Wait, I think this is the old one. Hold on, sorry. Is it?
The new one, unless someone made further changes.
Yeah, okay.
You guys want me to kick it off, or are we just reviewing it?
Yeah. So just to remind everybody what we're doing here, right now we're looking at the standalone revision to F because we want to make sure that we're not presenting an ambiguous revision in that the conduct that we're trying to capture here is not already prohibited under 7.3A and maybe B. I think that's part of the question too. Oh, okay. So even when not otherwise prohibited by this rule, so we're not just limited it to 7.3A.
Why did we strike the appearance of the service on the docket part?
Was that in the original?
Yeah.
I unfortunately dropped off for the end of the discussion, but the feedback that I heard was that it would just make it cleaner. But if that was not an intended strike, I can add it back in.
I think it's cleaner to have that, because that's the trigger that allows you to solicit, right? When you see it on the docket, and you can't then, as an attorney, just say, oh, I thought this person was served. You have to wait till it's actually on the docket. So I would be in favor of keeping it.
Eleanor.
Okay.
So we actually had this conversation when we were drafting and landed exactly where you're suggesting, Brandon. But Emil raised the concern during our discussions that could be arguably, more broad than required, because, perhaps what if it didn't show up on the docket timely, but the person had knowledge? I don't know how they would have this knowledge. So, we debated it and thought docket was clean and we should do it, and that was what Pennsylvania did. But if there is a concern about drafting this as narrowly as required to effectuate its intent, I think that would be one way to narrow it.
Well, I want us to talk about this, but I also want to talk about C, the advertising issue. Because if we have the standalone, so the question is we have the standalone as F, does the standalone as F now prohibit what really is going on here, which is, or what we think is really going on here is that they are sending these as advertisements, marking these solicitations under the pretext of advertisements. And so with this provision, They can't utilize that cover, basically, to reach these respondents in these domestic violence actions.
I read C as just explaining, is adding a requirement to a solicitation that is done under B or under this rule, but not as some carve out or some other avenue of reaching people in need of legal services. It's just saying if you're going to solicit, you have to mark it as an advertisement.
Right, and they can't use C to get around this rule, get around F, right?
No, but if they go through F, they still have to follow C.
But we don't want, that's, are we talking past each other?
No, I think what you are having is like after service, they are going to be able to solicit, so they have to follow C.
Okay.
Yeah, once they're able to solicit, they have to follow C.
Right. Okay, I see what you're saying. Okay. Okay, well, do we have any other, are we okay with this revision, and is this how we want to proceed?
One question, because you guys have dug into the text here. There was a question in my mind about whether every advertisement is a solicitation. And I think that, Carrie, you answered that it is. So by using the word solicitation in F, we're not limiting that in some way.
Sorry to interrupt. I don't believe every advertisement is a solicitation, but if we look at
Well, E defines solicitation.
Correct. So
which is a targeted communication.
Correct. That is directed to a specific person. So an advertisement would be a billboard. A billboard, theoretically, targeting one person could be a solicitation.
Okay. But a billboard anything that's not, these would all by definition be targeted.
I think what the goal here is to prohibit solicitation, but if you want to advertise, as somebody that can help you as a respondent in DV proceedings, that should totally be okay.
Correct. Yeah, I agree. People can advertise that they offer services to respondents in domestic violence proceedings. And if someone is served, but it hasn't appeared on the docket yet because they got served on a Saturday night, and then they see a billboard and they call that attorney, the attorney is still allowed.
Oh, I think we know what she was going to say. Aw. Okay, so the attorney is still allowed to contact or communicate with the respondent.
Accept whatever, yeah.
Yeah. Okay.
Well, I agree with Brandon's point and Eleanor's that the omission of the final clause actually makes it broader because it keys the trigger to service rather than docket entry, which doesn't happen timely in every jurisdiction.
Anything else? Are we in a pizza coma?
Yeah, I mean, just one other thought. I think it's correct, the first clause, the new addition, even when not otherwise prohibited by this rule. But my initial thought was if we put any limiting language in there, sometimes it can be used in the way that I did with the language in B to suggest a limitation. But I think it's correctly drafted. I think it's fine.
Even when not otherwise prohibited by this, like I'm in a coma right now because I'm like, no, I know. I know, but I'm like, okay.
Confusing to not have it. I actually think it works without it, but I think, I don't know, but I don't think it's wrong.
Trying to avoid the argument that it only applies when the targeted communication is not prohibited, not otherwise prohibited.
Could say notwithstanding any other provision.
But that, I think, actually
That's more
dictates even
problematic.
more, because then if you have a clause without that, does
Then
that
does it
mean it
just
should be
stay
read
C and-
differently?
yeah.
Yeah, I think it stands.
Even
alone, but
when not
I don't think
otherwise.
this hurts us.
Well, I agree. It would be fine without it, but I don't think it's a problem with it.
Okay. Even when not otherwise prohibited. Is everyone okay with this language? Are we still thinking? Mary Grace, you look confused.
Well, I just have a question about, because I don't, we're all kind of generalists and, sorry. So, because we're all sort of generalists, at least I am, and I don't practice, I've never done a DV anything. I'm reading the notice of the proceeding and the service of process. My question is about the legal procedure and how these things happen. Because I just don't know enough about domestic violence and when there is a restraining order and the order of, for the consumer so that it makes sense. Does that make, so if I'm seeking a restraining order, how does this all work? So then that would help me understand whether this makes sense. From like, does that?
Carrie, are you there? I think she's the expert on this, given she prosecuted it. I can give you my opinion, but I think she'd be.
If she's there she is.
I am so sorry. This is a nightmare.
Okay, did you hear the question, Carrie?
No, sorry, I just jumped back on.
No worries. So as I read this, because frankly, I've never practiced in this area of law. What I'm trying to understand is I understand the notice of the proceeding and the service within the docket, but what I would like to have a better understanding of is like the nuts and bolts of if I, as a, someone who's seeking a protective order, from when I start this process to when I, get the restraining order, in place, how does this work so then it makes sense if the attorney were sitting there listening and learning about it, so that they don't solicit?
So are you just asking about the timing of how DVROs go?
Yeah, so then it makes sense within the language that we're seeing here, because that's what I'm trying to understand.
Sure. So, and again, I'm sorry if I derailed us with the attorney sitting in the courtroom comment. That was just, I was trying to answer why the courts could not solve for this issue by somehow privatizing dockets until service appears or something like that. That was my only point of bringing that up. But the way that a DVRO goes is that a petitioner will file the paperwork and there's an ex parte hearing. And at that hearing, a temporary restraining order is issued, typically valid for something like 14 days. And that's how long the petitioner is given to serve the respondent. And the petitioner has control over when service occurs. And so that allows the petitioner to leave the court, to know that they have a restraining order in place, and then collect their things, contact shelters, whatever they need to do to get their, effects in order. And then once they have reached a place of safety, they can then have a private service or the sheriff serve the respondent. And at that point, the respondent then obviously can reach out to attorneys, can call the billboards that they've seen, can call the advertisements or Google it and look for attorneys that they want to contact. So we're not infringing anyone's rights to seek counsel, but what we're solving for is for that period of time where the petitioner is figuring out when they want to time service, to not allow attorneys in the name of generating business to jump the gun and to get in there and to put the respondents on alert of what's happening before the petitioner has had an opportunity to dictate the timing of the hearing, basically. And so, and let's say service occurs on the respondent the night before the restraining order hearing, the actual DVRO hearing, which is when the court is going to determine whether the we're going to say permanent order, but it's not a permanent order, but the order that's going to be for 3 or 5 years is going to be issued. If the respondent shows up and says, I didn't have enough time to find counsel, I was just served last night, it is their right to a continuance at that point. And so that's kind of how a timeline goes for a DVRO.
So based on that, I do agree that and such service appears in the court docket would make sense to leave.
Okay.
Well, even that clause in makes it a little probably later in time, obviously. It's going to be entered on the docket after it occurs. So that
yes,
more time.
So we don't want that. We want.
If there's a concern about making sure we're narrowly tailored.
Narrowly tailored.
And a lawyer should know if service was lawfully made or not.
Right.
Right. But, and also just from OCTC's perspective about one day maybe needing to actually hold a trial on this and how to prove the elements of it. If we leave something, if we leave ambiguity about when the attorney knew the respondent was served, that's going to create a lot of enforcement issues. So I do think that having it be on the docket is important for an enforcement standpoint. I know a lot of the issues with enforcing A is the pecuniary interest part of it. Like you have to prove that it's for like financial gain, and it's so amorphous. It makes it really hard to enforce.
So if you wanted to revise it, I suppose you could say has actual knowledge or has been entered on the docket.
But again, the attorney
standard, if you wanted to allow a knowledge standard.
But if we're trying to solve for the respondent has been served, but it's not on the docket, and we want the respondent to have access to attorneys, the respondent still can call attorneys. Like, it's not like the attorneys are prohibited from speaking with the respondents. It's just they're not allowed to go out and find them. But it doesn't prohibit the respondents from seeking counsel.
I completely agree. And I support it the way it's drafted, but I am sensitive to the concerns of some that we should be drafting it as narrowly as possible.
And Emil's earlier point was that you want to stay out of a situation where you are even arguably having a period where somebody's been served and they don't have access to who's a lawyer who does this, because this would be a window between somebody gets served and they hear from any lawyers until it gets entered on the docket.
So from a practical, can someone think of a scenario where an attorney would have actual knowledge that a respondent has been served, but it doesn't appear on the docket?
No idea.
Well, let's think it through for a second. You've got, I guess we're not doing it in B. If we were adding it to B, I could think of a scenario. In this case, what if you had a family member tell you they were filing against another family member?
But then it's family. Well,
but we're not under B.
Right.
I mean, I think we could come up with hypotheticals where that was the case.
Even without a hypothetical, if I'm one of these lawyers who provides this service, the argument is these people have been served, and I have to wait for the docket entry, which is arbitrary. I don't know when they even order these things, to go and tell them there's help.
So what if we said until there is actual knowledge, for example, service appearing on the docket?
I think that works.
Including but not limited to.
Yeah.
Well,
I think that works. I think actual knowledge is a reasonable standard, and attorneys should know. I don't think that'll be hard to enforce.
Right. it is a fact question, but it's not a complex one.
So let's try to, legal service, so where do we want to put actual notice? It should be, has actual notice of, no, wait. The respondent has been legally, till after the lawyer has actual notice or actual knowledge of the proceeding, or, for example, or including, wait, so where do we want to put the, until after,
Actual knowledge that the respondent has been legally served.
Exactly. Yep.
until after the lawyer, the lawyer has actual knowledge that the respondent, so, has been legally served. That's it, right?
Yep.
How do you feel about that in the context of the free speech and other rights tests? Is that too high a bar?
I don't think so. I mean, I think we just narrowed it a little bit.
We can't hear you, Eleanor.
Novella, go ahead.
Sorry about that. I said,
Sorry.
I think we've narrowed it. I think it's narrower. It's not as clear for, prosecuting it perhaps, but I still think it's pretty narrow and a reasonable standard, especially considering, we do have the family code section stating that there is a real threat to the public here, so.
Novella.
Is there a reason we're saying the lawyer has actual knowledge as opposed to the lawyer knows with an asterisk, given that know and known are already terms defined in the definitions for the rules?
No, there's no reason other than we didn't think of it, so thank you for thinking of that. Yeah, do y'all agree? I don't think we need to have actual knowledge, because knowledge is defined. So change the lawyer knows to the lawyer knows with an asterisk, yeah.
We could say, and it might be clearer to say, until after service appears on the court docket or the lawyer has knowledge. Lawyer knows.
Because
service has been effected.
then it's constructive knowledge, right? I mean, because it's.
That's right. That's why I'm trying to separate the actual knowledge from the docket.
Yeah. No, I think that's important. Okay, so why don't delete that part and put it at the end, or move that part and put it at the end. Until after the response. Wait, are we oh my God.
No, leave that there and then put, or such service appears on the court docket.
Yeah, so put back in.
You can just undelete that purple part.
Or just leave it.
Or just leave it.
Until after the lawyer knows.
Service, singular. Yeah. Carrie, what does that look like to you from like an enforcement perspective?
Yeah, I think that's it will be a little bit harder, to be honest, but I think it's doable.
Yeah, I mean, I think. I'm sorry. Go ahead.
So I was just saying, it'll be harder when somebody files a complaint with OCTC and alleges that a violation of this has occurred. They're going to have to be able to allege sufficient facts in their complaint that the lawyer didn't have actual knowledge in it, and versus just being able to print out the docket and say, look, the solicitation happened on this date and service wasn't on the docket until this date. But I think it's doable. They have a lot harder sections to enforce than this, so I think it's okay.
But knows, I think the definition of know says knowledge can be inferred from the circumstances right now, so.
Yeah, but is that constructive? No, that's not, a low bar is constructive knowledge. That's just circumstantial of actual knowledge. It's not, constructive knowledge is, if it's public, that's enough.
So it says, means actual knowledge of the fact in question. A person's knowledge may be inferred from the circumstance.
I don't think that's constructive knowledge. Yeah. I mean, who's OCTC, who's had to prove that knowledge element ever. Because it's not the definition of knowledge doesn't include constructive knowledge if it says actual knowledge.
Yeah, but again, this is saying that you can't do it until you know that,
Or you knew or should have known.
yeah, yeah.
And that's, but I don't think no includes should have known.
Yeah, but I mean, no, I think means that you have to have proof. Like, think of it like Rule 11. You have to have a Rule 11 basis to believe that the respondent had been served. So if you relied on somebody else telling you, like a, I don't know, process server saying, yeah, that person's been served, was that reasonable under the circumstances?
To show no, but but here they could have no actual knowledge, but just because it's on the docket should satisfy the rule. Whereas it's actual knowledge that wouldn't satisfy the rule of the definition of no.
Mm-hmm.
Does that make sense?
Well, we have the or.
Right, no, I think I don't know what I'm saying. What I'm saying is this is broader than the definition of know or knowledge under the rule.
Can we just,
I think you might, I mean, the question is whether or not, being on the docket would constitute knowledge under the rule, right?
Yeah.
We don't have to answer that.
Well, no, I mean, I think that we're adding a knowledge element that maybe, that's why she's saying it could be subject to challenge, right? But no, I think we want the knowledge element to be broader than the definition of actual knowledge. We're saying actual knowledge and constructive knowledge is encompassed within this rule.
When you're saying constructive knowledge satisfies it, is that based on the fact that you've got it appear on the docket?
Yeah.
Okay. So.
we're contemplating that
Would
this is,
appearing on the docket constitute actual knowledge? That's the question I can't really answer without looking at it. But
it shouldn't matter.
Either way, it's
Yeah.
okay.
Yeah, that's what I'm saying. Yeah.
we're assuming that the service is always personal service.
What, by service by publication?
Yeah, other methods of service or, a notice and acknowledgement or whatever. I don't know if those are applicable. We're thinking it's personal.
It's personal service.
Always personal service? Should we, okay. Can we put in the last clause, or proof of such service appears on the court docket? Because it wouldn't be the service itself, it'd be proof of service.
That's true.
Yeah, I like proof of such, proof, yeah.
Proof of service, yeah. That's a term of art.
Right, that's what I was thinking. Proof of that's, well, I think you could say proof of such service to make
Okay.
it explicitly clear.
So just a reminder about Pennsylvania, it says, the lawyer shall wait until proof of service appears in the docket.
Oh, look at you.
I'm an honorary Pennsylvanian.
Yeah.
I'm sure Pennsylvania grappled with all this and
Yeah.
Yeah.
they went with the docket, so.
Yeah, and I think it's good to use similar language. So let's say proof of service appears on the docket.
I would be okay with just the docket too.
Yeah.
I don't think there's a high risk that
It's a low bar.
it's a pretty standard way to know something occurred. And filing the proof of service actually perfects service.
Putting it on the docket is not required to do that.
No, but until that appears there, you don't know that service has been perfected.
Until after the lawyer knows. Is there any reason we would want to
So
take
the lawyer
out?
knows is kind of meaningless if that's true.
Are you sure, though? I mean, is there any reason why we would take out the lawyer knows that, other than we might think it's superfluous? No, I mean, I kind of like it. I think it's sort of, it captures all possibilities.
What possibility would it be capturing that the proof of service appearing on the court docket would not?
I have no idea, because I don't know. Did Carrie leave?
No, she's here.
Oh.
Or was. I mean, I think that,
Captures the period of time after service before it appears in the document.
Right.
Is that important to capture?
We can't hear you, Eleanor.
Apologize.
That's
Yeah, is
okay.
it important to capture the period of time between service and it appearing on the docket? I guess is really the question. And
is that an empty set anyway, is my
Yeah.
one thinking. Like if somebody got served and they call a billboard number, then you know, but they're telling you got served.
Right.
And you're not going to solicit them because they called you.
Yes.
And the lawyer gets these names from looking at the docket, the service, the proof of service. I mean, typically.
Well, they currently, I think they would get them just from the TRO proceedings.
Right.
Right, so we would want this to be, because it's not,
I'm fine with the docket.
I think
mean,
we should
did
just go with
grapple
just the
and went with
docket.
it, but it could be more narrow, but it doesn't need to be. Actually, I don't view this as really a significant interference with the right to counsel, which is my, you know.
Can we put it out to public comment with just the docket and then see if we get like a lot of comments saying that we should be including a knowledge element? I mean, we're just trying to get this like in a good enough shape to go out for public comment, right?
Yeah, I'd like that idea because I can't think of a circumstance where there would be anything in that category.
You might be right. It might be a null set because it's not perfected.
But maybe people will have it.
Right.
And if so, then they'll know from public comments.
okay. So let's take out, the lawyer knows that. And then we'll keep the respondent, until after the respondent has been legally served with notice of the proceeding or proof of service appears on the court docket. Oh, right. Okay, that's kind of what the original, right, this is what the original was. Okay, and with those, do we have any other comments, thoughts, revisions?
So just one question. So we still have the or in there.
Oh, right.
I think the original draft, it said and. Right? So the respondent has been legally served with notice of the proceeding. Should that be an and or or? I think it should be and.
Yeah, because like how, until after the respondent has been legally served. Because that's not, there's no knowledge element now attached to legally served.
What we came back with after lunch was until the respondent has been legally served with notice of the proceeding, period. We'd taken out the and such service appears on the court docket.
Yeah, it should be an and, not an or.
Yeah.
So it looks like the red line now is basically just reiterating what we'd taken out in the purple below. So do we like the red or the purple better?
The red, because it's
Red.
the same thing.
Okay.
And then we'll keep the purple above. And then we're gonna do it as a standalone. So what I suggest, okay, is it do it as a standalone? The other question I had, well, never mind. Do we have any other questions or revisions or thoughts? Because I think we should vote to, sorry, Eleanor? Go ahead.
This is just kind of to address the concern that it belongs with B. Should it be new C and then everything gets pushed down just to kind of make it
Oh, I like
flow
that
better?
idea too. Yeah, that makes that.
The benefit of not renumbering is that anything that cites the rule as it exists right now won't be confusing.
True.
Oh.
Section, so there will be opinions and other things that cite the rules subsections as they exist.
Good point. Okay, so I disagree with Eleanor now. Okay, so are we ready to take a vote as to whether or not we want to put this out for public comment? And then we want to know long for the public comment. And then I guess my only other thought is there anything we want to put in the description of the public comment, the memo for it? And that's up to Eleanor and Carrie. Is there anything specific that we want to ask the public to focus on, or although I think or staff can use its discretion to draft it up, obviously, but there's nothing specific we want to put in.
It might be helpful to cite the statute that references these findings. Isn't there a statute that you?
Yeah, the statute's in there. The only other thing, like, as you did point out that since we are looking at the solicitation rules closely right now, I know that there's been a lot of confusion and question around 7.3 lately. I think that we could also welcome other questions that the public has about other parts of the rule, since we're in here doing it. I've heard a lot of, conversations happening about, especially with wildfires right now. So just, we could throw it out there that if anyone had questions more generally about solicitation, we could consider them, but I don't know if we want to open that can of worms.
Yeah, that's a big can of worms. What do you think? I mean, I'll throw it to staff, to Rachel.
I mean, if we open up and invite comments on solicitation in 7.3 in general, all that would mean is that if we received public comments and the committee wanted to then act upon them and make further changes or modifications to 7.3, then it would go out for public comments again after that.
Yeah, my concern would be that I don't want this can of worms to drag down the goal here. So if we can, after we get public comments, if we're able to separate out, the general 7.3 issues and the this particular revision, and put them on separate tracks potentially, if we can divorce them in the future, I'm fine with putting that in the memo and would vote for that.
We don't typically just generically ask everyone's opinion about the rules.
Then that's kind of,
Right.
We don't,
so it would be like a specific change, because we'll get a lot of opinions about the rule. I know there's a lot of ambiguity potentially in it. So I would focus just on this particular F.
Okay, that makes sense. Yeah, then I take back my comment.
Okay, we can tackle the problem of 7.3 at some point in the future. Okay, so, and then what the public comment period would be 90 days? Is that 60 days?
Minimum 60, yeah.
60 days, okay. So let's take a vote for, anything else? Okay, so let's take a vote for approval to send this out for public comment. Is there a motion?
I move to send it out for public comment.
I'll second.
Who second that?
Vikita. Okay, can take the roll.
Yeah. Ali?
Yes.
Brown? Coleman?
Yes.
Guzman?
Yes.
Mercado? Mojave?
Yes.
Munoz? O'Reilly?
Yes.
Poindexter?
Yes.
Riley?
Yes.
Rabbi? Shivers?
Yes.
The motion carries.
Okay, thanks, you guys. That was a good discussion. Very productive. Okay, so now we're going to move on to the amendments to rules 8.2 and 8.4. Recall that we had voted that out for public comment, for those revisions out for public comments. This is the judicial threats comments to rules 8.2 and 8.4. Those were voted out for public comment. We received some public comment, two of which were, I think, were well taken. The question we have here is if we're going to make any substantive revisions, then we'll have to vote it back out for public comment. And if they're minor revisions, then we can vote it up for approval by the board. Either way, it's going to have to go through public comment again anyway. So it's not a significant issue, but I just wanted to let you know what the paths are here if we're going to vote it any kind of approval. So the rule. Can we put up the?
1 second.
What's going on? Just clarification.
I am going to pull the red lines for 8.2 and 8.4 from the January COPRAC agenda. So that is what I will be displaying.
Okay. Okay, so remember, Rule 8.2 is the one specific to judges. I actually don't have, let me pull it up here for myself. Never mind. Here, I'll just wait until we have that up there and then.
But this is the one where comment 1 was added with the Yagman site to 8.2, and then in 8.4 it was comment 7 and 8, right?
Yeah, hold on. Yeah, I think so. Hold on, I lost my. Because
Oh, and then a change to paragraph F too, to remove for purposes of this rule, judge and judicial officer.
I think that was, I don't remember. Hold on.
Yeah, it's been a while.
Okay, so, all right, yeah, so let's look at, good. Okay, so, comment 1, a statement that is asserted as opinion may be the basis for discipline if the statement implies actual facts that are capable of objective verification. The Bar Association of San Francisco made the comment that this comment does not state that the relevant statement must be false for it to be the basis for discipline, which is captured in Yagman, but and we got some comments from George Cardona on this. And so this comes from him, essentially, because Rule 8.2 already requires that it be, let's see, Rule 8.2A makes clear that the discipline requires that the lawyer make a statement of fact the lawyer knows or recklessly disregards to be false, knows is false or recklessly disregards the truth. So the comment, it wouldn't add anything really to include the requirement that it be false, but it doesn't hurt. So the proposal would be to add after verification, comma. So I'm going to have you do some.
Sorry, where in the document are you?
We're
in 8.2.
Yeah, 8.2 and in the proposed comment. And then where it says verification, so comma, after verification, put those facts are false, comma. And the statement, sorry.
Am I in the right place?
Yeah.
Okay.
And the statement is made with knowledge or reckless disregard of the truth or falsity of those facts. Yeah, and that goes before.
Sorry, can you read that again?
Do you have this? Yeah.
Statements made with knowledge. No problem.
So this just clarifies that, and it basically states the Yagman holding in full as it applies here. So it doesn't really change the meaning of either the 8.2 or the comment itself. Does anybody have any objections or thoughts about this revision? And I guess we can vote. Should we vote on this revision separately and then the 8.4 revision? No, we'll just do it all together. Okay. Okay, does anybody have any comments about this one? No? Let's move on to 8.4, because that's a bigger issue. Because I think this one, this revision would not, I think this one would be just a minor revision. This probably isn't one that triggers. Okay, so this one is 8.4, and really this was a comment from Orange County, the Orange County Bar Association, and it really just had to do with the objective standard sentence that is at the end of this comment. So this comment has to do with the areas, the 3 categories of unprotected activities. So it's let's see, a statement made with specific intent of producing imminent lawless action, a true threat of violence that is a statement that a reasonable observer would understand to be a serious expression. And then the third one is the statements made with reckless disregard. False statements basically, or reckless statements. And so the objective standard really only applies to that third category. And the way we have it here is that it's a kind of standalone requirement, and that implies it applies to all 3 categories. And George Cardona did agree with that proposed revision. So the actual revision, so we're going to have you do some more revisions, is after falsity of the facts. Let's see, it's,
Okay.
yeah, comma, do you want to look or do you want me to just read it to you?
You can read it.
Okay. Comment using an objective standard to determine, quote, what a reasonable attorney, comma, considered in light of all, bracket, their,
Is that, what's in the next sentence?
what? Their professional functions.
That is in the next sentence, yes.
Oh, yeah, sorry, okay. So, but that's gonna be deleted, that last sentence, so you can just cut. Under similar circumstances, so it ends with similar or certain, similar, under,
Okay.
would do under the same or similar circumstances, end quote. And then, do we have, I can't, can you scroll up a little? Yeah. Okay.
Where do you want to cite the cases, or both?
Right.
There's
They go at the very end. They go, it should be Yagman, Sandlin, and then see also Rule 8.2, and then 6068B.
Okay.
Wait, yeah, so at the very end.
Okay. Did I get that correct?
I think so.
We're citing Yagman and we're citing Sandlin.
Yeah, Yagman, Sandlin, and then 8.2A, and then 6068B. Should
Okay.
8.2A,
Period.
yeah, no,
Delete
that's
this.
right, that's right.
And then delete this, courts use an objective standard.
Correct.
Okay.
Just take a look at that citation style, because there's quotes in there, it's not clear which case they're quoting and when they're cited that way.
Maybe, see, yeah, I don't know. I can't remember.
The Yagman quote maybe should go where that language is cited instead of at the end.
Doing,
Okay, move Yagman up here.
no, because
Facts that are capable of objective verification?
After, yeah, I think that's right. because before, up to the blue part where that ends, put that.
Okay. Sorry, Word is not cooperating with me.
Yeah, when you're revising a red line, it's very difficult.
Yeah. I think I'm gonna have to retype it. It won't let me copy and paste. Okay, where are we putting Yagman?
After facts, the blue facts, where it switches color before using.
Okay.
That's correct, right? That's the clause that is citing Yagman.
I can't remember.
Well, it's what we put in the previous provision.
Yes, because that's what it was before I started going in here and doing additional edits.
Is there any quote from Sandlin in there? I can't remember.
I think, quote, what a reasonable attorney would use. That's the Sandlin
That's
quote.
the Sandlin
Yes.
quote? Okay. Okay. Maybe these aren't substantive changes.
These are not substantive changes. We just
No.
reordered it.
Yeah. I think we can vote it, well, and I don't think we need to vote on that issue, but we can reach consensus. Well, yeah. We can vote on that issue if you vote no on voting it up.
Because Yagman was already cited in this exactly in the same way.
Yeah.
I wouldn't think they're substantive.
No, I agree. What do you think? Well, when you're done, you can.
Yeah, give me
Usually-
1 second to catch up on my,
Yeah.
my edits. Okay, does
usually-
anyone have any issue if I just accept this part of it so that that goes away and then I can?
Yeah, no,
Okay.
and this can be cleaned up in later too.
Okay. Okay.
The second Yagman site in blue air comes out. Yeah.
Okay.
Then
Okay.
after the citation to 6068, that sentence comes out.
Got it.
There you go.
All right. Thank you.
Thanks. That's kind of a marathon.
Okay, yes. Sorry, did you have a question?
Well, so Erica usually weighs in on whether something's like substantive or,
Oh, yeah, no, I think because we already had all of this information in here, it was just some reorganization. I think that we are fine. If the committee wants to proceed with voting it out to go to the Board of Trustees.
okay. Is everybody ready to vote, or does anybody have any further comments on these revisions or anything else on the public comments or the comments themselves? Vikita, did you have any thoughts or anything about, since I think it's just the two of us, right, on the working
Yeah.
on it.
It is.
Yeah. Do you have any comments on, are you ready to, no?
No, I think we're ready.
Okay. Okay, well, can I move? Yeah, I'll move to vote it out to the board.
Second?
That's right. So I withdraw my motion, and I will ask anybody on the committee to make a motion.
I move to send it to the Board of Trustees.
All right,
Second that.
Eleanor and Dan moved to vote it to the Board of Trustees.
Okay.
Yes.
Ali,
Yes.
Just not the chair.
Brown, Coleman,
Yes.
Guzman,
Yes.
Mercado,
Yes.
Mohabi,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter,
You know what? Yes.
Ravi, Riley, Shivers.
Yes.
Motion carries.
All right, good job, everyone. Okay, I think that we're at the end of our agenda. We are at flat fees. And that is Brandon.
So this will be relatively quick.
We can't hear you, Brandon.
I'll try to make it quick. Nima and I want some more time with this to potentially expand it to account for big law. This opinion as drafted right now is currently geared towards unsophisticated clients. And it's our understanding that flat fees are being used increasingly in, large corporate transactions and things. So we want to look at it that way. We want to invite someone else to join our group. We think we could use another member of the working group. And then finally, the opinion as we have it drafted right now, we might be coming up with some more ideas for how to make it useful to practitioners. And even if we don't change it, we think we can consolidate and shorten it. It can be more concise. So I see a lot of people excited to volunteer.
It's going to be a great committee.
It's going to be good.
I can personally guarantee it.
Yeah.
Okay.
Emil, thank you so much.
Yeah.
And that's my whole report. I mean, look, is there a reason to go through the public comments? We got public comments. Most of them are not particularly persuasive to us and are assuming more of an adversarial posture than the tone of this opinion and what it's pointed at. So to a large extent, the public comments we thought were a bit off topic and not applicable.
That's fine, because I think you can talk about the public comments at the same time you're presenting and
Right.
whatever. So
Okay.
I think we can wait until next meeting.
Sure.
Okay, or the meeting after. Okay. I think that's it. Wait, what am I looking at? Is that the last thing on our agenda? Does anybody have anything else they want to talk about today at the meeting, now that we're all here in person? Emil?
So I wanted to bring up a bill that's currently in the Assembly. It's Assembly Bill 931 with Assemblymember Kalra from Sacramento. He has introduced a bill, and I believe it's currently in the Judiciary Committee. And the title of that bill, it has to do with consumer legal funding. And so it all has to do with litigation finance, mostly on the consumer side. But my particular point is whether we may be able to comment, and maybe we can ask staff if they can look into this. I know they're already tracking the bill, but if there's a way that we can comment and provide feedback to the legislature. I know, as everyone here probably knows, we are regulated in many different ways as lawyers in the state of California, unlike most other jurisdictions. But this one in particular may impact us both as lawyers and then us as a committee, because it directs essentially the State Bar of California to potentially go after lawyers or law firms who work with out-of-state alternative business structures. So for example, if a lawyer is properly licensed and practicing law in the District of Columbia, and the District of Columbia allows some level of non-lawyer ownership, like for example, maybe an accountant can be a minority owner in a law firm. The bill as drafted, if approved and enrolled, may make it illegal for that lawyer, a lawyer in California, to co-counsel or be pro hoc vice counsel or anything with that out-of-state lawyer. And I think while many people will say it implicates 5.4, non-lawyer ownership, et cetera, I don't think that's what 5.4 really covers. So I'd like us to comment on that. Right now, it says that a violation shall subject the attorney or law firm to a $10,000 fine or treble damages, attorney's fees, injunctive relief, and then discipline by the State Bar.
That's the proposed bill? That's the bill?
That's correct. This part of the bill, which aims to change Section 6156 of the Business and Professions Code.
Was that circulated? Did I miss it?
It has not been
Okay.
circulated. This is kind of a new matter I'm bringing up.
Got it.
Okay. I don't know, yeah, so we will, I don't know what we can do as far as making public comment or submitting a public comment to a bill in the legislature. So maybe we can ask staff to look into that process. And then as a committee, I mean, we can look into the ethics issues that exist like the 5.4 issue, and what the current, I'm thinking like an ethics opinion, I mean, and go down that track, but that'll be well after probably this bill. Well, I don't know. How long does it take for a bill to become a law in California?
I mean, there's an expectation that this could happen this session, so.
Oh, okay. So, yeah, I mean, so, we can look at what, what we can do outside of this committee as far as the public comment process, but also simultaneously look at, addressing the issues from an current ethics perspective based on the current state of the law. Anybody else have anything to add or thoughts on this? Interest? Yeah, I think it's a really interesting issue. I'm glad you brought it up.
Can you circulate it? Do you mind?
I'd be happy to, yes.
Okay, thank you.
And then let's put it on the agenda for the next meeting. So when is this session end? Like, what do you mean by this session? Is it, I don't know how, it's like this year?
Yes, they will. I'm trying to think when they actually close for the session. I believe it's in July it ends.
Oh,
So,
okay.
yeah, this may happen very quickly, so.
Okay, so yeah, let's try to keep, for the next meeting in June, then we can,
Emil, do you know that the intent is to address like the states where they're experimenting with alternative business structures? Preventing the importation of that?
Correct. So one thing I'll tell you, and I'll give you the exact folks that are, so if you read the Legislative Council's report, it says that the sponsor of the bill is the Consumer Attorneys of California, then the California Employment Lawyers Association, and then United Policyholders. As far as I can recall, United Policyholders tends to be anti-litigation finance, and Consumer Attorneys of California is, and probably California Employment Lawyers Association tend to be plaintiffs' lawyers. And I think my interpretation of the bill is a lot of it has to do with litigation finance, which I'm not really going to comment about. That's something that I think the legislature can deal with appropriately. But this particular issue is, I think, something that's best left to the regulation of lawyers by the court system and the state bar. And I think that's my concern here, is that it is being sped through as a small part of a larger anti-litigation finance bill. And I think it'd be nice for lawyers to have a voice or vote or something in that.
yeah, I agree. Okay. All right, with that, I think we're adjourned. Ooh, we should be both. All right, well, thank you all for coming in person, and thank you for coming in virtually, and enjoy your weekend, everyone. Thank you, and thank you guys for your first, yay! Rachel and Kathy.